under Articles 15.4 and 16.4 in the new reservations under 15.6 and 16.6 as bestowing double benefit is incorrect. What is described as benefits for those covered under Articles 15.4 and 16.4 by the Union cannot be understood to be a free pass, but as a reparative and compensatory mechanism meant to level the field, where they are unequal due to their social stigmatization. This exclusion violates the non-discrimination and the non-exclusionary facet of the Equality Code, which thereby violates the basic structure of the Constitution. The impugned amendment creates pathways, gateways, and opportunities to the poorest segments of our society, enabling them multiple access points to spaces they were unable to go, places and positions they were unable to fill, and opportunities they could not hope ever to ordinarily lose due to their destitution, economic deprivation, and penury. These destitution, economic deprivation, poverty are markers or intelligible differentia, forming the basis of the classification on which the impugned amendment is entirely premised. To that extent, the amendment is constitutionally indefeasible. However, by excluding a large section of the equally poor and destitute individuals based on the social backwardness and legally acknowledged caste stigmatization from the benefit of the new opportunities created for the poor, the amendment practices constitutionally prohibited forms of discrimination. The overarching principles under Articles 15.1, 15.2, 16.1 and 16.2 is that caste-based or community-based exclusion, that is the practice of discrimination, is impermissible. Whichever way one would look at it, the Constitution is intolerant towards discrimination and untouchability in all forms and manifestations which are articulated in Articles 15.1, 15.2, 16, 17, 23, and 24. It is equal prohibits exclusion based on past discriminatory practices. The exclusion made to the other than exclusionary cause negates these principles and strikes the heart of the Equality Code, specifically the non-discriminatory principle, which is a part of the core of the Constitution. The Sino Commission was set up. The Sino Commission was set up to examine the condition of economic backward and suggested measures, including the feasibility of reservations, to improve their law. The report published in July 2010 is based upon the census of 2001 and later surveys. The statistics NSSO 2004-2005, which the report is based on, disclosed that in all 31.7 crore people were below the poverty line, BPL, of which the scheduled caste population was 7.74 crores. That is 38% of the total of the scheduled caste population in the country. Scheduled tribe population was 4.25 crores. That is 48.4% of the total scheduled tribes of the country. 13.86 crores of OBC population, which was 33.1% of the total OBCs, and 5.85 crores of the general category, which is 18.2% the total general category. These facts established that the bulk of the economically weaker sections of the society belong to the classes described in Articles 15.4 and 16.4. I pass on to question number 2, which is that unaided private institutions, including those imparting professional education, cannot be seen as standing out of the national mainstream. As held in Pramati and Society for Unaided Private Schools, reservations in private institutions is not per se violative of the basic structure. Thus, reservations as a concept cannot be ruled out in private institutions where education is imparted. They may not be the state or state instrumentalities, yet the value that they add is part of the national effort to develop skill and disseminate knowledge. These institutions, therefore, also constitute material resources of the community. in which the state has a vital interest and are not merely bodies set up to further private objective of their founders, unlike in the case of shareholders of the company. Therefore, I hold that that on question number 2, the amendment is valid, but for reasons of answering question number 3, the amendment has to go. Before I sum up, I wish to address one point which the majority has dealt with, but more as a note of caution, because it is not necessary for me to deal with that aspect, which is the 50% cap. It is pertinent to note that the breach of the 50% limit is the principal ground of attack of the 76th Constitutional Amendment, 1994, which is inserted as entry 257A. The Tamil Nadu Backward Classes, Scheduled Caste and Scheduled Tribe Reservation of Seats in Educational Institutions under the State Act 1993. The validity of that enactment and whether the inclusion by the Constitutional Amendment violates the basic structure is directly an issue in a batch of cases pending before this court. The view of the members of this bench constituting a majority that the creation of another class which can be a recipient of up to 10% of reservation over and above 50% permitted under 15.4 or 16.4, in my considered opinion, therefore has a direct bearing on the likely outcome in the challenge in that proceeding. I would therefore sound this cautionary note, since this judgment may well seal the fate of the pending litigations without the benefit of hearing in those proceedings. The last reason why I find myself unpersuaded to agree with the opinion that the amendments, by creating a different kind of criteria, have to be viewed separately, and that Indira Sani was confined to reservations under 15.4 and 16.4, is because permitting the breach of the 50% rule, as it were, through this reasoning becomes a gateway for further infractions, which in fact would result in compartmentalization. The rule of reservation could well then become the rule of equality or the right to equality. Could then be easily reduced to a right to reservation, leading us back to the days of Champakam Durai Raja. In this regard, the observations of Ambedkar have to be kept in mind that reservations are to be seen as temporary and exceptional, or else they could eat up the rule of equality. The fraternal principle, I'm now summing up, the fraternal principle is deeply embedded to this nation's ethos and culture. The specific provisions which form part of the Equality Code are inextricably intertwined with fraternity as well. It is fraternity and no other idea which acknowledges that ultimately all individuals are human beings born through the same natural process, subjected to the same physical limitations, and finally leave this world at an unknown time but are sure to live. Fraternity is a concept awakens humans to the reality that despite our apparent or superficial differences, ethnic, religious, caste, gender, origin, or economic status, the institutions we create need our collective cooperation and individual commitment. Every social order invariably contains individual differences, be grounded on ethnicity, wealth, talent, or realization of one's abilities. The diversities abound. The idea of fraternity is to awaken to the consciousness of each member of society that our institutions which are created, the ideas that we develop, and the progress that we wish to achieve cannot be in isolation, by separation, but with cooperation and harmony. On this, I want to highlight the words of two social reformers, which demonstrate that the principle of fraternity and the ideas and values connected to it are not new, but in fact transcend time. Swami Vivekananda's message in his address to the World Parliament of Religions in Chicago on 11 September 1893 has the theme of universal brotherhood of all, that differences in religion, the exclusion of one of other would fade. He evocatively said, if anybody dreams of the exclusive survival of his own religion and destruction of others, I pity him from the bottom of my heart and point out to him the banner of every religion will soon be written, in spite of resistance, help and not fight, assimilation and not destruction, harmony and peace and not dissension. Aurobindo too was conscious of the need for fraternity. In a speech delivered in Havra in 1909, he presciently said, "Again, there is fraternity. It is the last term of the gospel. It is the most difficult to achieve. Still, it is a thing towards which all religions fall and human aspirations rise. There is discord in life, but mankind yearns for peace and love. This is the reason why the Gospels will preach brotherhood, which preach brotherhood, spread quickly, and excite passionate attachment. This was the reason for the rapid spread of Christianity. This was the reason of Buddha's spread in the country and throughout Asia. This is the essence of humanitarianism, the modern gospel of love for mankind. None of us have achieved our ideals, but human society has always attempted an imperfect and limited fulfillment of them. It is the nature, the dharma of humanity, that it should be unwilling to stand alone. Every man seeks the brotherhood of his fellow, and we can only live by fraternity with others. To all its differences and discords, humanity is striving to become one. Summary of findings in questions 1 and 3. On question 1, it is held that the state's compelling interest to fulfill the objectives set out in the directive principles through special provisions on the basis of economic criteria is legitimate. That reservation or special provisions have so far been provided in favor of historically disadvantaged communities cannot be the basis for contending that other disadvantaged groups who have not been able to progress due to the ill effects of poverty should remain so, and the special provision should not be made by way of affirmative action. Therefore, the special provisions based on objective economic criteria is per se not violated. However, in answer to question 3, I highlighted the framework within which it has been introduced by the impugned amendment, excluding backward classes. According to me, this is violative of the basic structure. A universally acknowledged truth is that reservations have been conceived and quotas created through provisions in the Constitution only to offset fundamental, deep-rooted generations of wrongs perpetrated on entire communities and castes. Reservation is designed as a powerful tool to enable equal access and equal opportunity. Introducing the economic basis for reservation as a new criterion is permissible. Yet, the othering of socially and educationally disadvantaged classes, including SCs, SCs, and OBCs, by excluding them from this new reservation on the ground that they enjoy pre-existing benefits, is to heap fresh injustice based on past disability. The exclusionary clause operates in an utterly arbitrary manner. First, it others those subjected to socially questionable and outlawed practices, though they are amongst the poorest sections of the society. Secondly, for the purpose of new reservation, the exclusion operates against socially disadvantaged classes and castes absolutely by confining them within their allotted reservation quotas. Thirdly, it denies the chance of mobility from reserve quota based upon past discrimination to a reservation benefit based only on economic deprivation. The net result of the entire exclusionary principle is Orwellian, so to say, which is that all the poorest are entitled to be considered regardless of their caste or class, yet only those who belong to other classes or caste would be considered, and those from socially disadvantaged classes would be ineligible. Within the narrative of the classification jurisprudence, the differential or marker distinguishing one person from the other is deprivation alone. The exclusion, however, is not based on deprivation, but social origin or identity. This strikes at the essence of the non-discriminatory rule. Therefore, the total and absolute exclusion of constitutionally recognized backward class of citizens is nothing but discrimination, which reaches to the level of undermining and destroying the equality code, and particularly the principle of non-discrimination. Therefore, on question 3, it is clear that the impugned amendment and the classification it creates is arbitrary, results in hostile discrimination of the poorest segments of society that are socially and educationally backward, and are subjected to caste discrimination. For these reasons, Articles 15.6 and 16.6 are struck down and held to be violative of the Equality Code, particularly the principles of non-discrimination and non-exclusion, which form an inextricable part of the basic structure of the Constitution. While this reasoning is sufficient to conclude that Article 16.6 is liable to be struck down, there are additional reasons elaborated in Part 5, due to which this court is compelled to clarify that while the economic criteria per se is permissible in relation to access to public goods under Article 15, the same is not true of Article 16, the goal of which is empowerment through representation of the community. For the above reasons, it is hereby declared that Sections 2 and 3 of the Constitution 103rd Amendment Act 2019, which inserted Clause 6 in Article 15 and Clause 6 in Article 16 respectively, are unconstitutional and void on the ground that they are violative of the basic structure of the Constitution. The writ petitions are consequently disposed of. It would be in order to place my gratitude and appreciation for the valuable assistance rendered by all counsel and all the counsel assisting them.
I have concurred with the view taken by Honorable Justice Ravi in its entirety. So effectively, the decision speaks to prove.
So you may feel grateful to the Lord.
We are expressing a deep gratitude for the assistance rendered by every one of you in whatever capacity as the lead counsel, as even as nodal counsel. These two counsel did excellent job. So it was a great learning experience for all of us, and this I express gratitude on behalf of all the members who are part of this bench. My colleagues also join me in expressing that. Thank you so much.
Present bench, not a pleasure to argue before your lordship. Greatly obliged.
We are grateful for your lordship is to accommodate and hear everyone. We are very grateful for that, your lordships.
The operative portion will be like this. In view of the decision rendered by the majority consisting of Honorable Justice Dinesh Maheshwari, Honorable Justice Bela M. Trivedi, and Honorable Mr. Justice J.B. Pardiwala, the challenge raised to the 103rd Amendment to the Constitution fails. The writ petitions and other proceedings filed in that behalf stand disposed of accordingly. Thank you.
Grateful to your lordship.
Sir, may I also thank the bench for a very patient